discrimination, Israel restricts every aspect of Palestinians' life, from birth to death, resulting in manifest human rights violations and an overt system of repression and persecution. Treated as a burden and a demographic threat, Palestinians' rights to life, liberty, and their fundamental freedoms are systematically denied. In East Jerusalem, by revoking thousands of residential permits, Israel has transformed the Palestinians with deep ancestral roots into temporary residents who can lose that residency and the right to live in their city at any moment. Through indiscriminate killing, summary execution, mass arbitrary arrest, torture, forced displacement, settler violence, movement restrictions and blockades, Israel subjects Palestinians to inhumane life conditions and untold human indignities, affecting the fate of every man, woman, and child under its control. For Israel, Palestinians are by definition guilty. Hence, it comes as no surprise that the conviction rate for Palestinians held before Israeli military courts stands at 99%. In the words of the Special Rapporteur, and I quote, Israel's all-encompassing criminalization shows that the military legislation, rather than safeguarding security, renders every single Palestinian potentially subject to imprisonment for ordinary acts of life, end of quote. By contrast, despite the call by the Security Council for Israel to disarm the settlers, their violence continues, aided and abetted by the Israeli government and military. This is part and parcel of this Israeli domination and discrimination enterprise. Settlers are rarely, if ever, prosecuted for crimes against Palestinians, ravaging them with absolute impunity. Even some states friendly to Israel have now decided to sanction some of the violent settlers themselves, as Israel fails to do so. Palestinians and Palestinians only endure horrific levels of extensive human and material losses, including home demolitions enforced as collective punishment. All of this has created a coercive environment that facilitates Israel's forcible displacement of Palestinians. As described by the Special Rapporteur, and I quote, collective punishment is an inflamed scar that runs across the entire Israeli occupation of Palestine. Notwithstanding numerous resolutions, reports, and reminders critical of its use, Israel continues to rely upon collective punishment as a prominent instrument in its coercive toolbox of population control. The logic of collective punishment has been to project domination in order to subdue a subjugated population through inflicting a steep price for its resistance to alien rule. In Gaza, this collective punishment has reached unbearable levels. Hermetically sealed from the outside world by 17-year air, land, and sea blockade with no end in sight. The situation in Gaza was described as early as 2016 by the Secretary General as collective punishment for which there must be accountability. In the absence of accountability, Gaza is besieged and bombed. Massacres perpetrated for more than 140 days now, and nearly the entire population forcibly displaced and at risk of perishing. Mr. President, this prolonged repressive regime has dehumanized Palestinians, denying them the right to life, the right to safety, the right to even exist while confining and fragmenting them and their territory. The court is not facing isolated or individual acts violating Palestinian human rights, but rather the cumulative effect of systematic policies undoubtedly constituting a pattern of racial discrimination. Members of the court, the policies and practice of Israel amount to segregation with the existence in the occupied Palestinian territory of two entirely separate legal systems. These are not my words. These are the words of the Committee on the Elimination of All Forms of Racial Discrimination, tasked by more than 180 states to fight the scourge of racial discrimination. Likewise, the UN International Commission of Inquiry has described the situation in the OPT as legal regime of segregation. When it comes to determining that a measured policy or practice disproportionately affects a group, this court attributes considerable weight to reports of several UN organs and monitoring bodies and to the constant practice of independent treaty bodies. The findings of independent treaty bodies are a fortiori to be ascribed great weight when their findings are shared by the UN General Assembly, the Human Rights Council, special rapporteurs, as well as by almost all the participants in the present proceedings. Members of the court, Israel's occupation has been replete with systematic exclusions and restrictions adopted with the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights. As noted by the Special Rapporteur on Human Rights, and I quote, "The political system of entrenched rule in the occupied Palestinian territory that endows one racial, national, ethnic group with substantial rights, benefits, and privileges, while intentionally subjugating another group to live behind walls and checkpoints and under a permanent military rule. Sans droit, sans égalité, sans dignité et sans liberté satisfies the prevailing evidentiary standard for the existence of apartheid. Apartheid exists in the occupied Palestinian territory. 20 participant states expressly hold the same position, including victims of apartheid, South Africa and Namibia. As all states parties to the CERD, Israel is under obligation to particularly condemn racial segregation and apartheid. Undoubtedly, apartheid falls within the scope of discriminatory measures referred to in the UNGA resolution requesting this advisory opinion. This court, as early as 1971 in its Namibia opinion, also confirmed that apartheid amounts to a flagrant violation of the purposes and principles of the Charter. Further, the ILC has listed the prohibition of apartheid as a preemptory norm, permitting no derogation. Applying the definition of apartheid, which reflects customary law, in both the 1973 Convention on the Suppression and Punishment of the Crime of Apartheid and the 1998 Rome Statute of the International Criminal Court, Israel's policies and practices in the OPT meet the evidentiary standards for the existence of apartheid. First, the existence of two or more different racial groups is present. International law determines racial groups by the subjective perception of the group that it has a separate identity. Judged by this standard, two distinct separate racial groups coexist in Palestine, namely the indigenous Palestinian population and Israeli Jews. Second, the establishment of an institutionalized regime of systematic oppression and domination by one racial group over another undoubtedly exists. As evidenced in the State of Palestine's written statement, Israel has in purpose and in effect elaborated through laws, military courts, violence, discriminatory zoning and planning, and collective punishment the system to subjugate Palestinians. They are confined in space and rights. They travel on segregated roads, a phenomena that even apartheid South Africa never knew. Third, the commission of inhumane acts is endemic. Israel subjects the Palestinians at unprecedented levels to inhumane acts as defined by these two conventions. Such inhumane acts include murder, forcible population transfer, massive arbitrary arrest, imprisonment, and torture. And while the occupation continues, they are becoming more egregious every year. Finally, the inhumane acts are committed with the purpose of maintaining the apartheid regime, and by it, maintaining permanently Israel's illegal occupation of Palestinian territory. As was shown by Mr. Reichler, the statements of Israel's highest government officials evincing Israel's determination to dislocate the Palestinian population, annex its territory, and maintain its system of colonial settlement all attest to Israel's intention to maintain an apartheid-based occupation regime permanently. In July 2014, Israel's then Minister of Justice declared, and I quote, "What's so horrifying about understanding that the entire Palestinian population is the enemy? They are all enemy combatants, and their blood shall be on all their heads. They should go, as should the physical homes in which they raised the snakes. Otherwise, more little snakes will be raised there." End of quote. Tragically, this is just one of the many dehumanizing descriptions by Israeli officials of Palestinian children. Snakes. Snakes, Mr. President. For all the above reasons, the State of Palestine requests the court to declare that Israel's discriminatory practices against the Palestinian people are tantamount to apartheid, which this court defined in its 1971 advisory opinion on Namibia as distinctions, exclusions, restrictions, and limitations exclusively based on grounds of race, color or descent, or national or ethnic origin, which constitute a denial of fundamental human rights. This actually reflects the Palestinian reality. Mr. President, members of the court, 47 United Nations experts have declared that if the occupation is not brought to an end, and I quote, "What would be left of the West Bank would be a Palestinian Bantustan, islands of disconnected land completely surrounded by Israel and with no territorial connection to the outside world, and would be the crystallization of an already unjust reality. Two peoples living in the same space, ruled by the same state, but with profoundly unequal rights. This is a vision of a 21st century apartheid. This is apartheid." The Palestinian population in Israel stands at 20%. Hence, Israel's discriminatory treatment of Palestinians must be viewed in its totality. As Palestine and other participants demonstrated in their written statements, the system of racial discrimination extends to all areas between the Mediterranean Sea and the Jordan River. Furthermore, Palestine, Namibia, and South Africa, together with a myriad of public figures, legal scholars, NGOs, concur that such discriminatory treatment amounts to apartheid. Even some Israeli officials admitted it. Although it might not be clear to the naked eye, by Israeli law, Jewish citizens of any country who have never been to Israel can automatically gain Israeli citizenship. Yet, Palestinians, refugees who have spent their entire lives in forced exile and in refugee camps are barred forever from returning to their homelands. Unfortunately, time won't allow me to expose the full extent of Israel's discriminatory laws, but I would only highlight that Israel has an extensive set of laws discriminating against Palestinians in every aspect of life. This was not left unnoticed by CERD, which noted that the practice of segregation between Jewish and non-Jewish communities continues to be applied in Israel proper. A one-state reality of unequal rights, consolidating segregation and apartheid against Palestinians, is reflected in the inherently discriminatory character of the 2018 Basic Law, Israel, the nation-state of the Jewish people. Under this law, exercising the right to national self-determination in the State of Israel is unique to the Jewish people. Developing Jewish settlements became an Israeli national value, not only in the occupied West Bank and the Syrian Golan, but even in Israel. And I ask where? On which lands? The answer is on the lands where Palestinian citizens of Israel live, especially in the Galilee and the Naqab. An exclusive right of one group and complete denial of the rights of another. From the Jordan River to the Mediterranean Sea, if this is not apartheid, what is? Israel's measures, policies, and practices against the Palestinian people are no less pervasive in their reach or less pernicious in their consequences than the institutionalized racial discrimination and segregation that existed in South Africa. And just like in 1971, the international community relies on this court to play its own genuine role to bring about an end to this glaring injustice. An immediate end to this illegal situation will bestow on the Palestinian people the fundamental rights to which they are entitled by international law, yet unfortunately they have been so unjustly denied. Let me conclude, Mr. President, with a cry of desperation representing the countless victims of the ongoing Israeli atrocities as described by the Palestinian poet Mourid Barghouti. In my despair, I remember, there is life after death, there is life after death. And I have no problem, but I ask, oh God, is there life before death? Mr. President, members of the court, I thank you for your kind attention. Mr. President, I respectfully request that you now call Professor Sands to the podium. Thank you very much.
I thank Mr. Nagum. I now invite Professor Philip Sands to address the court. You have the floor, Professor.
Monsieur le Président, Mesdames et Messieurs les membres de la Cour, j'ai l'honneur de m'adresser à vous ce matin au sujet du droit du peuple palestinien à l'autodétermination, de la privation prolongée de ce droit inaliénable et de sa quête permanente pour l'exercer pleinement. 53 autres États et 3 organisations internationales ont déposé des observations écrites auprès de la Cour. Aucun d'entre eux, aucun, même pas Israël.
Fully. 53 states and 3 international organizations submitted written statements to the court. Not a single one, not even Israel, claimed that the Palestinian people was not entitled to self-determination under international law.
Mr. President, the written statements before you offer no discordant note to the 3 core propositions that the State of Palestine advances in these proceedings. First, the Palestinians are a distinct people. Second, as such, they enjoy the very same rights as every other people, including that most foundational of rights, namely the right to self-determination, to decide for themselves how they will live and organize politically, socially, economically, in accordance with and subject to international law. As Professor Hirsch Lauterpacht put it in 1945, in the language of another age, freedom means, and I quote, the right of self-government through rulers chosen by and accountable to him, and equality demands an equal opportunity of self-government and cultural development. End of quote. Third, the Palestinian people's right to self-determination has real and practical consequences. It is not an empty slogan. That right includes, but is not limited to, the right to control their own land and natural resources, the right to be free from demographic manipulations by any third party, and the right to determine their own political status, economic development, their own futures. Mr. President, members of the Court, there is no dispute as to the right of self-determination of the Palestinian people. It has never been an issue, not since the time of the mandate. And this Court made that clear 2 decades ago in its opinion in the War case, when it said loud and clear, the existence of a Palestinian people is no longer an issue. What is before this Court now is the ability of the Palestinian people to exercise that right, and Israel's systematic and prolonged violation of that right. What does the right to self-determination mean in practice? How has Israel violated it? And what are the consequences of those violations? Mr. President, members of the Court, in its written statement, the State of Palestine explained that the right to self-determination comprises 4 specific components. First, the right to territorial integrity. Second, the right not to be subjected to demographic manipulations within that territory by a foreign power. Third, the right to exercise permanent sovereignty over its natural resources. And fourth, the right to be able to pursue its chosen economic, social, and cultural development. The prolonged occupation, colonization, and purported annexation by Israel of Palestinian territory, with all the discriminatory and other unlawful acts, have and continue to deprive the Palestinian people of each of these 4 distinct components. Let me start with the right to territorial integrity, so recently recognized and given effect by the Court in its advisory opinion on Chagos and endorsed by an overwhelming majority by the General Assembly of the United Nations. This implements Resolutions 1514 and 2625. Yet Israel has clearly violated the territorial integrity of the occupied Palestinian territories through over more than half a century of belligerent occupation. As Mr. Reichler has described, it has purportedly annexed Jerusalem and the West Bank, and it has established hundreds of settlements populated by more than 700,000 settlers regarded as a permanent part of Israel. It has extended the wall that this court found to be illegal in 2004. It has confined Palestinians to enclaves. It has severed Jerusalem. It has restricted Palestinian rights of entry from the rest of the OPT. It has transformed the Gaza Strip into an impoverished enclave, a besieged, bombarded community severed from the West Bank and East Jerusalem. Its leaders have declared that Israel will be sovereign over all the land between the Jordan River and the Mediterranean Sea, and it has made this formal government policy. What's the consequence of this? It is the acquisition of territory by force. It is the reduction and fragmentation, as you have seen, of the territory left for the Palestinians. And this is a manifest violation of Palestine's territorial integrity, its unity, its contiguity, which are core elements of the right to self-determination. The General Assembly, the Security Council, the Human Rights Council have repeatedly called for the preservation of Palestine's territorial integrity and condemned Israel's acts as a violation of the right of the Palestinian people to exercise their self-determination. And so we urge the court to declare Israel's 56-year occupation to be unlawful, to confirm, to take the words of your recent opinion in the Chagos case, that Israel is under an obligation to bring its presence on the territory of Palestine to an end and to do so as rapidly as possible. Mr. President, members of the court, I turn to the right not to be subjected to demographic manipulation. The Palestinian people, as you've heard and are aware, have been subject to a century of dispossession and displacement in manifest violation of their right to self-determination. This is in two ways. First, the forcible displacement undermines the integrity of the people, as the court has confirmed in the Wall and Chagos opinions. Between 1947 and 1949, during the Nakba, between 750,000 and 900,000 Palestinians were forcibly displaced. In 1967, a further 400,000 were forcibly displaced. Refugees are prevented from being able to return. And forcible displacements continue today. Entire communities in the West Bank, including East Jerusalem, are now before our very eyes on a daily basis across the entirety of Gaza. Second, transferring another people into the territory of Palestine is contrary to international law. It undermines the exercise by Palestine of its right to self-determination. Yet Israel declares it continues, it violates the right of self-determination. The law requires that such actions must end forthwith. Mr. President, members of the court, the third aspect is the right to exercise permanent sovereignty over natural resources, as recognised by Article 1 of the two international covenants and by so many UN bodies. The resources include land, fresh water, agricultural and mineral resources, including hydrocarbons. Israel's control and purported annexation of the occupied Palestinian territories embraces both the land and its natural resources. For example, Israel systematically appropriates water resources. In the West Bank alone, the United Nations has documented prohibitions on Palestinians drawing waters from the River Jordan and grossly inequitable allocations of vital groundwaters as between Israelis and Palestinians. Israel pillages rock quarries. Israel prevents Palestinian exploitation of hydrocarbon deposits onshore and offshore. These too are manifest violations of the right of self-determination. Mr. President, members of the Court, the fourth component of the right to self-determination is the right of a people to determine its own political status and direction and to pursue its own economic, social and cultural development of its choice. This is confirmed by a multitude of instruments and General Assembly resolutions. Yet Israel persists in prohibiting and punishing political expressions of Palestinian identity and nationhood. Flags are outlawed and attacked. Civil society organizations and political parties are declared to be unlawful. Leaders and elected representatives and civilians more generally, including so many children, are assaulted, exiled, imprisoned, or killed. General Assembly resolutions and many treaties confirm that these rights exist under international law, and they've been systematically violated. The economic, social and cultural rights of the Palestinian people are suppressed by a prolonged and unlawful occupation, by the purported annexation of the West Bank, including East Jerusalem, by the settlements, by the wall and its associated regime and infrastructure, by the blockade of Gaza, by the fragmentation of land, by the deprivation of resources, by the restrictions on freedom and movement of people and of goods, and by a multitude of other acts of subjugation and collective punishment. These acts and others have curtailed the access of the Palestinian people to livelihoods. They have made the country and the people totally dependent on aid. Cultural development, too, is under sustained assault. Access to religious and cultural sites is restricted, and the centuries-long historic status quo at Jerusalem's Christian and Muslim holy sites, notably at the Al-Aqsa Mosque, is undermined and violated. Religious, social and cultural events are stopped. Schools and universities are besieged or just demolished. Cultural heritage is usurped or just destroyed. Writers, poets, academics are simply prevented from expressing themselves, and some, like the renowned poet Rafat al-Arir, has simply been killed. Religious leaders face intimidation, harassment, and incitement. And so too it goes for Palestinian social development. The World Bank, the World Health Organization, has described the health system in the occupied Palestinian territories as fragmented and fragile. Access to housing is destroyed by forced expulsions, demolition orders, seizure and destruction of property, discriminatory planning, violence and intimidation from settlers. In the Gaza Strip, the economic, social and cultural life of the Palestinian people has been decimated. After 17 years of blockade, the population is destitute. It is subjected to destruction on an industrial scale, now utterly dependent on humanitarian aid merely to exist. This continuing military assault today shocks the conscience of the world. Is it consistent with the right of self-determination, Mr. President? One only has to ask the question to see how it answers itself. The violence and restrictions imposed on Palestinians impact every aspect of Palestinian life, That's UNCTAD reporting in March 2003. And of course today the situation is even more grave. The violation of Palestine's exercise of the right to self-determination is manifest and it is gross. In summary, Israel has arrogated to itself the right to decide who owns Palestinian land, who may live on it, and how it is to be used. On Israel's approach, it decides on the use of resources and allocations of benefits. On Israel's approach, it decides whether Palestinians remain or return. On Israel's approach, it decides how, if at all, Palestinians may meet, trade, teach, worship, live, love. And Israel wants more. Its current Prime Minister and government celebrate the denial of Palestinian exercise of self-determination, of sovereignty and statehood. They celebrate it. They claim a right to construct settlements in the Palestinian territory. And with pride, they speak of the power to frustrate the Oslo Accords and Palestinian statehood, the ultimate expression of the right of self-determination. Mr. President, let us be blunt. Israel has sought to negate the rights of the Palestinian people to exercise their right of self-determination in all aspects across all parts of the territory of mandatory Palestine. It has done so for decades and it wishes to do so forever. Tragically, Israel celebrates the manifest violation of international law inherent in its prolonged occupation. Tragically, Israel asserts the right of national self-determination in the State of Israel, and I'm quoting, is unique to the Jewish people under its own 2018 basic law. Tragically, Israel sets its face against the role of international law. No one in this great hall of justice is starry-eyed about international law, but it is what we have. And it is your role as judges of this court, the principal judicial organ of the United Nations, to affirm the place and the power of international law, to confirm the illegality of the occupation, to make clear that Palestine in all respects meets the criteria of statehood under international law with all the rights and responsibilities that implies. Mr. President, members of the court, the existence and exercise of the right to self-determination are not conditional. The right is a peremptory right. This is recognized by states, by judges of this court, by the International Law Commission, by commentators. And what that means in practice is that there is no derogation from the existence or exercise of the right. In Chagos, the court confirmed that Resolution 1514, which recognizes self-determination, must be exercised without any conditions or reservations, reflects customary general international law. The only limitation on the right, the court has said, is that the free and genuine expression of the people concerned has to be exercised in accordance with international law. In Chagos, this court swatted away British and American arguments that alleged security concerns somehow trumped the right of self-determination and its exercised. And we trust that the court will dismiss the argument that somehow the Palestinian people's right of self-determination is conditional upon a subjective determination by another state as to matters of its security. This right to self-determination includes the right of a people to form a sovereign and independent state. more than 140 states have recognized Palestine as a state, with a population, with a defined territory, with a government, being a party to multiple treaties, a state with rights and with obligations. Mr. President, members of the Court, Palestinian statehood is not dependent on the approval of Israel. An occupying power does not have and cannot have a right of veto over the right of self-determination of the Palestinian people. The inalienable rights of the Palestinian people include the right of self-determination, national independence, and sovereignty. What are the consequences of Israel's violations of Palestine's right to self-determination and its exercise? Professor Pillay is going to address these matters, so I can be brief. As the purpose and effect of the occupation is the denial of the right of self-determination and the prevention, let's be frank, of the solution called for by the Security Council, the General Assembly, and the vast majority of states of our world, premised on the existence of the two-state solution, the occupation is illegal and must be brought to an immediate, unconditional, and total end. The right of self-determination requires that UN member states bring Israel's occupation to an immediate end. No aid, no assistance, no complicity, no contribution to forcible actions, no money, no arms, no trade, no nothing. All UN members are obliged by law to end Israel's presence on the territory of Palestine, period. In concluding, Mr. President, members of the Court, may I respond to the unfortunate point made by a small number of states that an opinion from this Court would somehow negatively impact future negotiations. With great respect, the truth is the very opposite. First, the Court has confirmed already the Palestinian people have a right to self-determination without derogation. The existence and exercise of the right to self-determination is not and can never be a matter for negotiation. Second, the function of this Court, of these judges, of you, is to state the law, to spell out the legal rights and obligations that will allow a just solution in the future in conformity with international law. The political context is totally irrelevant. The legal questions in Namibia, in the Wall case, in the Chagos case, all had a political context. But the Court did not blink. It has never shied away from drawing the consequences of the right to self-determination. In Chagos and in Namibia, the advisory opinions have been significant and positive in their outcomes and effects. By identifying the applicable legal principles and then applying them to the facts, the Court performs a most significant, uniquely significant role for protagonists and for the international community as a whole. With great respect to my friends from the United States and Britain, it is the very opposite of what they have written. The function of this Court in interpreting and applying the right of self-determination of the Palestinian people can only assist in a solution based on the law, by setting out the parameters required by the law to resolve the matter. A forthright advisory opinion from this Court makes a resolution more likely, not less likely. Mr. President, in 1945, Professor Hirsch Lauterpacht wrote that self-determination is an enlightened and beneficent ideal to which the formation of states must conform if both justice and the peace of the world are to be secured. That is the beating heart of self-determination. The idea that a people must be able to determine for themselves their lives and their futures. And Hersch Lauterpacht personally knew of what he spoke. And we know that he was right. Israel's actions, as you have heard already today and will hear in the coming days, are manifest, grave and continuing violations of the right of which Lauterpacht spoke. And we invite this court to so declare, to help bring to an end this affront, to allow the Palestinian people to determine the conditions under which they will live in their territory, under their government, under the law, and to do so fully and to do so forthwith. That's what international law requires, no more and no less. Mr. President, I thank you for your kind attention, and I invite you to call Professor Pelley to the bar.
I thank Professor Sands. I now invite Professor Pelé to address the court. Vous avez la parole, Monsieur le Professeur.
I will.
Monsieur le Président, Mesdames et Messieurs les juges, mes collègues ont résumé dans le
Mr. President, distinguished members of the court, my colleagues summed up in the limited time which they had the principal internationally wrongful acts to be attributed to Israel. Those
tiens de récapituler tout aussi brièvement
precisely described not only in the written comments of the State of Palestine, but also in those of the vast majority of the 56 other states and international organizations who have participated in the written proceedings. So it falls to me right now to succinctly recapitulate not these egregious violations themselves, but the legal consequences arising from them. These consequences are the very subject matter of those two questions posed by the General Assembly to the Court, since both of them relate to the legal consequences of the prolonged occupations of the OPT. Were I to restrict myself merely to commenting on the list alone of the internationally wrongful acts of which Israel is responsible, were I to do that, I would exceed by far the time at my disposal. May I thus be allowed, distinguished members of the Court, to refer you to the passages in our written comments and those of the majority of states and international organizations participating in the written proceedings who set out these consequences in particularly relevant and careful fashion. Those references will be listed thanks to the diligent efforts of the registry in the reports of this hearing, and can also be seen in the overview table, which you can find under tab AP1 of your judges folder. It's rather a long table, I have to say. I'm going to say a few words about that in a minute. In any event, this listing calls for a number of comments, both preliminary and general. Firstly, as emphasized by the participants in the written proceedings, who are all in agreement on this point, the legal consequences for Israel arising from the applicable rules are primarily those codified by Articles 29 through 37 of the 2001 ILC draft on state responsibility. These deal, of course, with the full reparation of harm caused by actions or omissions of Israel, but also with their cessation, inseparable from the duty to carry out those obligations breached and the obligation to offer guarantees of non-repetition. Another point on which there is a very broad consensus relates to the nature of those obligations breached. Now, generally speaking, the participants to the proceedings consider that these are serious violations by Israel of obligations arising from the peremptory norms of general international law, whose definition and consequences are partially codified in Articles 40 and 41 of the Articles of the ILC. This is the case principally for the prohibition of acquisition of territory by the threat or use of force, the obligation to comply with the right to self-determination, a number of rules arising from humanitarian law or the protection of human rights, and specifically the prohibition of racial discrimination and apartheid. Let me point out en passant that this enumeration overlaps strikingly with the non-exhaustive list of norms that the ILC had previously designated as having this status of peremptory norms, which were annexed to the draft findings on peremptory norms of general international law, Jus Cogens. My colleagues have shown this at length, and I will revisit this again solely to illustrate the particular consequences which flow from the very nature of peremptory norms. Let me clarify, however, that these peremptory principles you can see in the table on screen are set out in greater detail on the in the document that you can find under tab AP33 in your files. The reason why it's helpful to single out these obligations is on account of their specific consequences. First, and this is the starting point, given that they are peremptory norms, they are binding upon and independent of the consent of their recipients. Secondly, unlike what some states would wish you to believe, you can't interpret them as derogating either from the rules of Jus Cogens nor from the Charter of the UN, which constitutes the supreme norm, creating both the Security Council and the Court, and which, of course, binds them both. Furthermore, in no circumstance can exclude the wrongfulness of any act of a state which does not comply with an obligation arising under peremptory norm of general international law. This principle is codified by Article 26 of the ILC Articles of 2001 and is recalled by the equally important draft conclusion 18 of ILC drafts on peremptory norms of general international law. And finally, Israel can't hide behind alleged circumstances precluding wrongfulness to justify the violation of its obligations, which are peremptory and intransgressible. Let me add that these considerations are equally valid mutatis mutandis regarding the obligations flowing from the resolutions of the Security Council, and first and foremost, of course, from those decisions taken under Chapter 7 of the Charter. And you can see the relevant list under tab 3 of your folders. In no case may negotiations call into question the norms of Jus Cogens, one of whose main consequences, as you well know, is the voiding of any treaty if, at the time of its conclusion, it conflicts with the peremptory norm of general international law. So, the conclusion of negotiations may in no case be contrary to the peremptory norms which I set out just a few minutes ago, nor contrary to the binding resolutions of the Security Council, though these resolutions generally rehearse the former, applying them to the specific context of our case. Mr. President, contrary to what the US implied in their written comments, the holding of negotiations is not necessary for us to draw the consequences of Israel's violations of its international obligations. Once violations has been established and attributed, and in this case this is beyond dispute and indeed is undisputed, the responsibility of their author exists ipso facto with all attendant legal consequences. Now, to deny this, some states, a few states, have invoked inter alia one sentence quoted out of context, taken from your opinion of 9 July 2004 in the Wall case. I quote, This tragic situation can be brought to an end only through implementation in good faith of all relevant Security Council resolutions, in particular resolutions 24-2 1967 and 33A 1973. End of quotation. But all you said there is that the state of Palestine, which is ready to do so, and Israel, which appears far from it, must apply the resolutions of the Security Council. And they must do this both during and independently of any negotiations. And in your opinion on the wall, you never considered that the so-called negotiating framework prevented you from ruling on the legal consequences of its illegal construction. May I add that neither Resolution 242 nor Resolution 338 refer directly to the responsibility of Israel for its practices and policies towards the Palestinian people. Only the second one of those, the Resolution 338, calls for, I quote, calls for negotiations between the parties concerned under appropriate auspices aimed at establishing a just and durable peace in the Middle East. So it's not a question of responsibility, and this question is as topical as ever. Now, sticking to the wall opinion, you called the General Assembly's attention, and I quote you here, to the need for these efforts to be encouraged with a view to achieving as soon as possible, on the basis of international law, I repeat that, on the basis of international law, a negotiated solution to the outstanding problems and the establishment of a Palestinian state, existing side by side with Israel and its other neighbours, with peace and security for all in the region. Let me underscore, on the basis of international law, sur la base du droit international. Another consequence of the peremptory nature of the norms breached by Israel is that Israel cannot rely on any circumstance to escape its responsibility, be it on the grounds of some consent purportedly given by the state of Palestine, or by invoking self-defense or necessity. No more may Israel justify countermeasures as a response to an internationally wrongful act that it might impute to Palestine. As the ILC noted quite rightly in its commentary of Article 26 on its articles of state responsibility, I quote them there. For example, a state taking countermeasures may not derogate from such a norm. The plea of necessity cannot excuse the breach of a peremptory norm. End of citation. The State of Palestine does not deny that to practically implement Israel's obligation towards it and the Palestinian people, that negotiations could be useful, indeed necessary. But as far as peremptory norm obligations are concerned, this would only be to settle practical issues. There is no way that such negotiations, or the perspective of such negotiations, could serve as a pretext to exonerate Israel from its responsibility, or lessening their consequences, or delaying their implementation.
Yeah, thank you. Yes, thank you. I apologize. Mesdames.
Distinguished members of the Court, as you will recall, not only the State of Palestine, but also a number of other participants, the obligations incumbent upon Israel to draw the consequences of its internationally wrongful acts are unconditional and immediate. That's the case for the obligation to put an end immediately and unconditionally and completely to the occupation of Palestinian territory, including East Jerusalem. This is an occupation, as you well know, lasting almost 57 years. As I say, the obligation to put an end immediately, unconditionally and completely to the occupation of Palestinian territory, including East Jerusalem, an occupation lasting almost 57 years, violating inter alia the prohibition of the acquisition of territory by the threat or use of force, the right of the Palestinian people to self-determination, the prohibition of racial discrimination and apartheid, and those fundamental principles protecting human rights and arising from humanitarian law. Now, it's also the case for the obligation to cancel all legislative or regulatory texts aimed at annexing East Jerusalem or any part of the territory of East Palestine in disregard of its territorial integrity, as well as those organising the exploitation of its natural resources. The obligation as well to put an end to the policy of apartheid and racial discrimination of which the Palestinian people as a whole is victim, both in the OPTs and in Israel. This is also the case of the obligation to rescind all measures aimed at modifying the demographic composition of occupied territory, including Jerusalem and the status of the holy places. And in the same spirit, the prohibition to establish diplomatic missions in Jerusalem. The same applies to the obligation to dismantle settlements in the OPT, or the obligation to ensure the return of Palestinians expelled from Israel and from OPT and their descendants, and to restitute properties confiscated, be they property, both real and personal property, to their Palestinian owners, and to pay them, the owners, inter alia appropriate compensation, and further, the obligation to search for, prosecute and punish the authors of war crimes, crimes against humanity, including apartheid or genocide, or other egregious violations of human rights. May I be allowed to refer you, members of the court, to the table you can find at tab 6.1 of your folders, which summarizes, on the basis of the replies of both the State of Palestine and a number of other participants in the proceedings, those legal consequences on which you are called to rule. Mr. President, the secondary obligations, if you will, that I've enumerated thus far are the consequence of Israel's practices and policies pursued in persistent and egregious violation of the obligations of peremptory norms of general international law, and in first place of its illegal occupation, its denial of Palestinian people's right to self-determination, which is the source of all these evils. Were Israel to effectively and swiftly acquit itself of these obligations, Israel would be partially re-establishing the situation which existed before the wrongful act was committed. Without that, of course, adequately repairing the immense harm caused to the people of Palestine since the 1948 Nakba. To the extent that this harm cannot be repaired by restitution, Israel must discharge two other obligations consistent with the principles codified in Articles 34, 36 and 37 of Articles 2001. Israel must compensate the victims of its acts and give satisfaction in reparation of the damage caused by its internationally wrongful acts in the form of recognition of its breaches, expressions of regret, formal excuses, or by any other suitable means. I won't say more about compensation except to recall that reparation must be entire and that it is essential for those Palestinians who are direct victims of Israeli atrocities inter alia on account of the infringement of human rights and humanitarian law. And in particular, I quote, the applicability of the Geneva Convention relative to the protection of civilian persons in time of war of 12 August 1949 to all the Arab territories occupied by Israel in 1967. End of quotation. This is a Security Council resolution. I continue. But in the framework of the instant proceedings, distinguished members of the court, it falls to you to affirm the principle of compensation and not the quantum. However, you can be more precise regarding the satisfaction that the State of Palestine is entitled to expect from Israel, especially given that the Security Council and the General Assembly have already made specific and legally binding findings in this respect. The Security Council in 1967, I quote them, talks about the acknowledgement of the sovereignty, territorial integrity and political independence of every state in the area. This appeal to Israel remained without effect, but ought to have, and indeed should more than ever, encourage those states who have not yet done so to follow the example of the 139 states who've already recognized the State of Palestine. In that self-same resolution, the Council calls for, I'm quoting them again, the guarantee of the territorial inviolability and political independence of every state in the area. Every state. That includes, of course, without doubt, the State of Palestine. Now, these decisions, and these are binding decisions, were rehearsed, reiterated on numerous occasions since the important resolution 2334 of the Security Council of 23 December 2016, which is particularly important. And because it's so important, you will find it under tab 6.4 in your folders. It has to be said that Israel paid no attention to this either. Now, Mr. President, if ever there was a situation in which these guarantees of non-repetition foreseen by Article 30 of the Articles of the ILC apply, it is this case. For almost 57 years, despite the repeated appeals of the General Assembly and the Security Council of the UN, and numerous other international organizations, be they NGOs or governmental, Israel has obstinately stuck to its policy of oppression and discrimination against the Palestinian people in breach of the most fundamental principles of international law, and by its practices has continually exacerbated the situation with the unconcealed objective of making impossible the realization of the Palestinian people's right to self-determination. Let me point out once again that the Security Council has for many years expressly called upon Israel to discharge all of these obligations, as you can see in the table under tab 6.2 of your folders, which summarizes all the relevant resolutions of the Security Council. And the General Assembly insisted time and again on, I quote them, the urgency of achieving without delay an end to the Israeli occupation that began in 1967, end of quotation. And of course, as well to bring to an end the other violations of Israel and its obligations whose urgent nature it emphasized by saying immediately. Mr. President, given that it is legally impossible for Palestine to renounce requiring Israel to comply with its peremptory obligations, the cogent nature and the seriousness of their violations by Israel have major consequences for third states. Now, they are set out a minima in Article 41 of the ILC articles. The Security Council and the General Assembly have repeatedly called upon all states, I quote, not to provide Israel with any assistance to be used specifically in connection with settlements in the occupied territories. More broadly, they have equally reasserted the obligation of the UN and all states not to recognize the situation resulting from the unlawful occupation of Palestinian territory, not to provide aid or assistance, to make the distinction between occupied Palestinian territory and Israeli territory, and to comply with and enforce international law. This implies that the responsibility of Israel should be implemented and that the resolutions of the Security Council should be applied by practical means. Excuse me. Mr. President, the principles set out in Article 41 describe some of the essential and indispensable consequences of any serious violation of the obligation of the peremptory norms of international law. Such norms are rare, it is true, but Israel has seriously and systematically breached most of them and continues so to do. So Israel must assume the consequences, and it's up to the court to remind Israel of them and to specify the contents thereof in the light of the facts of the case. Once again, because I don't have the time and because iterari iadem omnia diabolicum, I humbly request you to refer to the relevant paragraphs of our observations, in other words, of our comments and written statements. I'll merely recall in telegraph style that third states, starting with the UN, must prohibit the provision of Israel with any military or technological assistance which could be used in the OPT, including Gaza, of course, to perpetuate or reinforce its occupation and the regime of racial discrimination and apartheid instituted by Israel. This prohibition covers all authorizations for any type of arms trade which could be used to such ends. Third states also have to aid and assist Palestinian people, including refugees from the time of Akbar up until those who have fled recent Israeli atrocities, giving them the means necessary for their subsistence inter alia via competent international organizations. And that will surely include UNRWA. Third states they must refrain from any form or economic relations or other relations with Israel involving the population or the natural resources of the OPTs without the express agreement of the legitimate representative of the Palestinian people. Third states also must ensure that their own nationals do not pillage nor unduly appropriate these said natural resources. Third states have the obligation to cooperate with a view to effectively realizing the right of the Palestinian people to self-determination. They must also prosecute and punish all individuals responsible for serious crimes under international law, including their own nationals, before national courts or by cooperating with the ICC. Now, there is a point on which I'd like to more especially draw your attention, distinguished members of the court. This relates to paragraph 3 of Article 41, which specifies that it is without prejudice to further consequences that without prejudice to further consequences that a serious breach, as defined by Article 40, may entail under international law. End of quote. As from then, the obligation of third states and the UN don't stop at these duties of cooperation and non-recognition. As Palestine explained in its written comments, they have an obligation, both customary and conventional, to pursue, punish or extradite the authors of violations, be they war crimes, crimes against humanity, the crime of apartheid, not to mention acts of genocide committed against the Palestinian people, whose plausibility you recognized in your order of 26 January. Moreover, you expressly recalled in your opinion on the war, I quote you here, all states parties to the Geneva Convention relative to the protection of civilian persons in the time of war are under an obligation, while respecting the UN Charter and international law, to ensure compliance by Israel with international humanitarian law as embodied in that convention. This obligation covers all crimes committed by or at the instigation of Israel. Distinguished members of the court, I think that no case that you've had before you, be it contentious or advisory, has raised so many very, very serious questions as those on which you are called to rule today. The number of participants in these proceedings, 57 during the written phase, 54 who will be participating in these hearings, bears witness to the importance of the stakes in play and to the conviction of the international community of states as a whole that the court has a crucial role to play to help put an end to the dramatic situation created by Israel's breaches of the most intransgressible principles of international law. Like a large number of states and international organizations, Palestine detailed in its written observations the consequences of the very numerous and serious violations of international law committed by Israel, including most of its most fundamental rules. Palestine considers that it falls to you to guide the General Assembly, the UN and all states to ensure that Israel finally complies with those obligations upon it, stemming from its repeated, systematic and continuous breaches of the most fundamental principles of international law, which, let me repeat, all these principles, all these violations have been brought about by the prolonged occupation of Palestine, which is surely the mother of all its violations. Your opinion, distinguished members of the court, will be a very precious guide for Palestine. The state of Palestine is fully aware that you can't just wave a magic wand and put an end to the Israeli occupation and the tragic situation of the Palestinian people. But Palestine is persuaded that by firmly and precisely setting out the legal consequences of Israel's persistent violation of the rights of the Palestinian people, you can, by your opinion, make an appreciable contribution to putting an end to this terrible injustice and work for a just and lasting peace, allowing each state in the region to live in security. End of citation. In accordance with the Security Council injunction of 64 years back. And at the same time, you will fulfill your primary function to ensure the compliance of international law that your court administers. So thank you very much. I would be very happy if you could call His Excellency Dr. Riyad Mansour for the final submissions.
I'll give the floor to His Excellency Mr. Riyad Mansour. You have the floor, Excellency.
Mr. President, honorable members of the court, I think you have in your folders the full text or the original text of my speech, but I tried, in light of the lateness of the hour, I shortened it further. As we gather here in this great hall of justice, in the Peace Palace, we are reminded of these simple words. peace through justice, peace through law. The General Assembly brought the question of Palestine before the court because our people, the law, and peace are in jeopardy. The clarity of the law as it pertains to this question is only matched by the evidence of its continued breach by Israel. As we address you today, this breach has reached its most inhumane levels. More than 2 million Palestinians in Gaza are being pushed all the way to the border, to the very brink. Palestinian children, women, and men consumed by disease, despair, destruction, and death, which are spreading like wildfire. In the rest of occupied Palestine, settlers rampage and terrorize. No village, town, or city, no community, no sanctity spared. Israeli leaders no longer feel the need to hide their intentions. They speak openly of getting rid of the Palestinian people one way or another. They defy the law, and the law is barely fighting back. For Palestine, the law continues to be only a measure of the severity of breaches, rather than a catalyst for action and accountability. What does international law mean for Palestinian children in Gaza today? It has protected neither them nor their childhood. It has not protected their families or communities. It has not protected their lives or limbs, their hopes or homes. We are a proud and resilient people that has endured more than its share of agony. It is so painful to be Palestinian today. How could we be just subjected to such loss and injustice, such lawlessness and humiliation, time and time again? What does international law mean for a nation bestowed with inherent rights but enjoying none? It took 75 years for the UN to commemorate the Nakba, our violent dispossession, displacement from our land, and denial of our rights and existence. And we are seeing it happen all over again. Massacres, millions forcibly driven towards the unknown, tents, starvation, deprivation, and dehumanization, enabling one people to impose all of this on another. Palestinians under occupation in Israel as refugees and in the diaspora, all they ask for are their rights and to live in freedom and dignity in their ancestral land. For 75 years, the Palestinian people have faced attempts to push them out of geography and indeed out of history. And it goes on, and it will go on forever, unless and until international law is upheld, unless and until the unlawful occupation of Palestine ends. Mr. President, members of the court, our right to self-determination was recognized in the context of a mandate 100 years ago, yet simultaneously negated by the actions of the mandatory power. The question of Palestine was passed on to the United Nations at the time of its inception and has remained on its agenda ever since. In the aftermath of the Nakba, the United Nations admitted Israel to membership while emphasizing the need for it to respect Resolution 181 and 194 concerning the Palestinian state and the territory allotted to it, the international status of Jerusalem, and the right of return of Palestinian refugees. Israel recognized these resolutions to secure its admission, only to renege on them as soon as it was admitted. Ever since Israel became convinced that the new realities imposed by the use of force would override the obligations arising from the rule of international law without any consequences. In 1967, the Security Council emphasized the inadmissibility of the acquisition of territory by war and called for the withdrawal of Israeli armed forces from territories occupied in the recent conflict. Instead, Israel started to colonize the land. The General Assembly in Resolution 3005 called upon Israel to desist the annexation of any part of the occupied territories and the establishment of Israeli settlements on those territories and the transfer of parts of an alien population into the occupied territories. Instead, Israel formalized its annexation of Jerusalem and other parts of the West Bank and poured hundreds of thousands of settlers into our territory. In 1974, 50 years ago, the General Assembly reaffirmed the inalienable rights of the Palestinian people in Palestine, including the right to self-determination without external interference, the right to national independence and sovereignty, as well as the inalienable right of the Palestinians to return to their homes and property from which they have been displaced and uprooted, and called for their return. Instead, Israel denied the existence of the Palestinian people. The United Nations has consistently reiterated these calls, yet Israel has consistently rejected them, entrenching its violations rather than ending them. So here we are. Though the law is absolutely clear, it is being trampled. Without accountability, there is no justice, and without justice, there can be no peace. Israel must be made to bear the consequences of its illegal conduct rather than reap the benefits. After 75 years, justice can no longer wait for the day Israel has an epiphany and suddenly decides to reverse course and commit to the law and UN resolutions. Our journey in the search for justice has brought us before you, before the International Court of Justice, following the General Assembly's decision to seek your guidance. We call on you to confirm that Israel's presence in the occupied Palestinian territory is illegal. I repeat, it is illegal. That the presence of its occupation forces and settlers is illegal, and that its occupation must thus come to an immediate, complete, and unconditional end. I repeat, an immediate, complete, and unconditional end. This occupation has served as cover for Israelis' colonial designs, the acquisition of Palestinian territory by force. In 1980, the Security Council reaffirmed the overriding necessity to end the prolonged occupation of Arab territories occupied by Israel since 1967, including Jerusalem. If the occupation was deemed prolonged in 1980, how should it be characterized today, nearly 45 years later. I repeat, if the occupation was deemed prolonged in 1980, how should it be characterized today, nearly 45 years later? And if it was an overriding necessity to end it then, what exactly is it now, I ask you? Mr. President, members of the Court, the United Nations admitted Israel in 1949. 75 years later, Palestine is yet to be admitted as full member of the United Nations. I sat in the General Assembly next to representatives of liberation movements, next to the ANC and SWAPO. We stood side by side with them as they achieved their independence and took their rightful places among the community of nations. They cannot accept that the Palestinian people are left behind any longer, indefinitely denied their innate rights. That is why many of those states will appear before this court in the coming days. Mr. President, members of the court, based on the UN record, you should have no difficulty arriving at the conclusion that the occupation is prolonged, that Palestinian territory has been annexed, that our self-determination has been denied, and that the people of Palestine have been subjected to systematic racial discrimination. The occupation itself cannot be distinguished from these breaches. They are not merely the result of the occupation, but are rather the foundation upon which the occupation rests. Rooted in the singular unlawful goal of maintaining permanent Israeli dominance over the occupied Palestinian territory and relegating the Palestinians it has not been able to displace to inferior status in their own land, in perpetuity deprived of their inalienable rights. A finding from this distinguished court that the occupation is illegal and drawing the legal consequences from this determination would contribute to bringing it to an immediate end, paving the way to just and lasting peace. In closing, honorable judges, the State of Palestine appeals to this court to guide the international community in upholding international law, ending injustice, and achieving a just and lasting peace, to guide us towards a future in which Palestinian children are treated as children. Not as demographic threat, in which the identity of the group to which we belong does not diminish the human rights to which we are all entitled. A future in which no Palestinian and no Israelis is killed. A future in which two states live side by side in peace and security. The Palestinian people only demand respect for their rights. They ask for nothing more. They cannot accept nothing less and nothing else. The future of freedom, justice, and peace can begin here and now. It is within your power to give the clearest statement possible on what the law is, what it requires, and what it means in practice for all members of the United Nations. We trust in your wisdom, your fairness, and your dedication to justice and the rule of law, and I thank you very much, Mr. President.
I thank His Excellency Mr. Mansour. This concludes the oral statement of the State of Palestine. Your statement brings to an end this morning's session. The court will meet again tomorrow at 10 a.m. to hear South Africa, Algeria, Saudi Arabia, the Kingdom of the Netherlands, Bangladesh, and Belgium. The sitting is adjourned.